Alison Thewliss.
Thank you, Madam Deputy Speaker. We have another bill caused by Brexit, which this House is having to legislate on. And in sanctions and in money laundering, EU cooperation has been absolutely crucial to this. And we have moved it quite far along the road together as friends and as neighbours and colleagues. And there are a lot of concerns that have been made around this bill about the justification of the proportionality, about the direction that this takes us, and whether it takes us in the right direction with giving us enough opportunity to correct some of the flaws that we have within our own systems. Sanctions has been laid out by others who've spoken are effective when we have cooperation, particularly as an EU bloc. And that reflects also the limitations that we have in sanctions that come from the UN Security Council, because there will not always be agreement on those sanctions from the permanent members of the Security Council. So we need to find our place here. Our place here is not within the EU as it was. It is not entirely as other states are in the world. We need to find out where we are within this. And Tom Keating from RUSI has said that we may have greater flexibility as a result of this, but we certainly will have less influence. And that's something that the ministers need to bear in mind. And I see the Secretary of State has scuttled off without hearing me, which is kind of him. Without the cooperation of ministers with the EU, and that will have to be a very active type of cooperation, a very active engagement with that, we will not be able to be the most effective in imposing sanctions. We should not, Madam Deputy Speaker, pour our own collective efforts over the years down the stank just because we're leaving the EU. Unilateral sanctions bring with them a recognised risk that while we might want to do the right thing, that there may be repercussions, and being part of the EU, being part of a collective action, cushions us to an extent from that risk. We do not want to be marginalised in the world, and we must take care to make sure that that doesn't happen. Before I move on to other... Of course.
The Honourable Lady has made a very valid point, but obviously when it comes to the issue of Brexit, I have a very different opinion from the Honourable Lady. Nonetheless, does the Honourable Lady not agree that our ability to implement sanctions and address money laundering are essential components of our exit from Europe? And it's vital we have the same protections in place that in the international market, and if anything, we must look at perhaps maybe even enhancing those and making them even stronger.
I would agree with them that perhaps we can enhance, and we should enhance in many different ways what we do here. But we must take care not to lose what we've got so far, and to make sure that we don't lose that sense of cooperation, that sense of common purpose against evils in the world, which we have had as part of the EU. The Honourable Member for British Auckland mentioned human rights within this, and I very much support the points that she made as part of this. And I think perhaps the government ministers who spoke on this didn't quite recognise that the points, that clause 1, 2, E, F, G and H, were actually there in this bill because they were moved by a Labour Lord. And I'm glad... I thought she may have made that point, but I didn't want to let it pass without having recognised it. The government should not be taking credits for things that they did not do and did not put in this bill. These are things that we should have on the face of the bill, and anything that can go to enhance the importance of human rights within this bill should be there. Now, the NGO Sanctions and Counter-Terrorism Working Group, which is chaired by Bond and the Charity Finance Group, have asked very much for protection in law for humanitarian and peace-building work currently inhibited to a degree by the EU regulatory framework on sanctions. And as the member for Sutton Coldfield laid out very well, aid in parts of the world and aid operations in parts of the world which are extremely dangerous and under sanctions from the UN and the EU still have to have aid workers in those countries. They have to build up relationships on the ground which we may not be comfortable with, which may be difficult, but without which aid could not happen. But at the moment, and within the scope of the bill, there is not sufficient protection here. Section 14 talks of general licences. Section 36, Clause 36 of the bill puts out a bit more focus on guidance. 37.1 says the Minister who made regulations must issue guidance, but 37.2 says guidance may include guidance about compliance, enforcement and disregards. That's not really concrete enough. That guidance should be absolutely more certain so that people know the regime that they're working under, they know the risks of what they're about to do, they know if there's going to be any comeback from the actions that they take. I don't think that's quite clear enough, and I would like to see improvements to this area of the bill. They require more concrete assurances, and that assurance is shared by the banks as well. And the UK Finance, in their briefing on this bill, say that they fear, of course, that these things could be misused, but there has to be a way of getting around this. And they give the example of banks that they know avoiding any transactions whatsoever to do with Iran due to the risks of being sanctioned by the US, because their sanctions regime is quite far-reaching. And they say that that has a chilling effect on their transactions in that area just due to the risk, not due to the actual certainty that that will happen, but just due to the risk. And those sanctions will have an impact on those countries for many years to come, as organisations sort of get back into that regime even after sanctions have ended. They have to have the confidence that they can deal with that country and that their dealings with that country can be consistent over a number of years, that sanctions, once they have ceased, will not suddenly reappear and they will find themselves foul of that. Because people working in those countries need to interact with donors, with banks, with transport and logistics companies, and they need to have comfort on that. They need to buy fuel, they need to buy mobile phones, they need to make payments to move about the country and to let aid flow. And Yemen's an example of this, where you can't move around the country because there are different forces imposing different visa regimes in that country. So to actually move around the country, you need to be able to make payments, perhaps to people that may find you foul of sanctions. UK Finance have also, of course,
I appreciate the comments the Honourable Lady is making. Is she in effect agreeing with the Law Society of Scotland's interpretation of the need from the beginning of the bill in Clause 1 for there to be a list of all sanctions, including descriptions of any designated person, types of sanction which are imposed, and also the exemptions from such sanctions, etc. Is that the thrust of the point she's making? Because I do agree with that.
I thank him for agreeing with me. It's very rare and very nice. I thank him for it. But yes, there has to be a good deal more clarity. There has to be a good deal more clarity, and I welcome the Law Society's view on that, because it isn't clear within the bill. And if people are working in that environment, they need to have that certainty. And for aid to flow and for banking transactions to flow particularly, there has to be a bit of clarity there as well. UK Finance are also seeking further detail in Clause 18 of the bill about extraterritorial application. They want to know exactly what a UK element constitutes and what their reporting obligations might be under that regime, because that, again, is not entirely clear. Madam Deputy Speaker, scrutiny and transparency as we go forward in this bill are somewhat lacking. There's a lot of scope in this bill for ministers to create significant new criminal offences by secondary legislation, some of which would carry a sentence of 10 years in prison under Clause 17.6. And that's constitutionally unacceptable to me that type of thing should be created by ministers in this way. And the House of Lords, it's not just me saying that, Madam Deputy Speaker, the House of Lords Constitution Committee want beefed up parliamentary scrutiny, and the House of Lords Delegated Powers Committee say that this confers exceptionally wide powers which are capable of being applied to a very wide range of persons, with a very wide discretion being given to ministers to determine the persons against whom sanctions measures may be applied. So we should be concerned about this, and we should seek to get corrections to this later on in the process. And I'd like to say that the Secretary of State, who has left his place, may not make decisions in haste, but we have to be concerned about the future as well. This is not just a bill for just now, this is a bill for many years to come. So the powers that we put in this bill are very important. The House of Commons European Scrutiny Committee currently looks at the EU sanctions that go through, and we need to know what the process will be within this place to scrutinise and to replace that process, because it is important to ensure that things are being done properly and above board. Within the bill at Clause 21, 4A and B, and 25, 3A and B, there is a mention of a review process being 3 years from the laying of a sanction. And I would like to get a bit more clarity from the Government as to why particularly that is 3 years, because I understand the EU process only has it as 1 year. Now, the Secretary of State laid out in some of his speech that there is an ability for a person who has been subject to that sanction to request from the Secretary of State that this is reviewed. But I think, given that circumstances change, given the way of the world today, that perhaps 3 years is perhaps just a little too restrictive, and we might want to push that down a little bit further, or at least give scope for it to be varied given the circumstances. Moving to Clause 41 and the Henry VIII clause there and the power to authorise additional sanctions, that is very much like the other clause that I just mentioned. And again, the House of Lords Constitutional Committee, when they looked at this, had concerns. This allows for the amending of the definition of sanctions and again gives lots of powers into the hands of a minister. Now, what is the mechanism, what is the clause, what is the parliamentary check on this? Where is the means for Parliament to have its say, for committees of this House to have their say on the scrutiny of this, because it is fundamentally important that there are checks and balances within this system. The Honourable Member for Barking and the APPG on responsible tax, of which I am a member, I'm quite pleased to see her amendment as regards beneficial ownership, and I will look forward to hearing her, hopefully, later on in the debate, talking about this a wee bit more. And there's a lot of issues around working with overseas territories and crown dependencies, and as much as I do not wish this House to legislate on Scottish matters, I would not want us to legislate for overseas territories and crown dependencies without consent. And that consent is very important. If we want to get buy-in and compliance, imposing things upon people may not necessarily be the best way of doing that. And I fully accept that. Yeah.
I thank for giving way, and I think she does hit on a very, very important point, that if we are to have changes made in the Crown dependencies, overseas territories, then it must be by persuasion rather than imposition. And would she agree that so far, using persuasion, there have been significant changes in the way, the transparency within those countries, and that perhaps should be the thrust of government policy in future, to ensure that these areas do not become the place where money can be hidden and laundered?
I think we have to be very careful, because there's an extent to which you push people and you give them the carrot, and there's a sense to which you have the stick there. And you have to kind of weigh up in all of this where exactly they are on that continuum and where exactly they are on that compliance. But I would seek from the ministers what conversations have they had with the likes of Guernsey and Jersey? What have they got confirmation of a permissive extent clause? I'm very keen to see open registers, and the member from Sutton Coldfield laid out some points on this excellently, that if the registers are there, they should be publicly available. I want to see transparency everywhere. But we also need to bear in mind that we have a long way to go ourselves in making sure that everything that we do is absolutely correct and proper also. There are clearly issues and disputes amongst people's interpretations of this, and having read one of the submissions by Jersey and Guernsey, their account of affairs is quite different to other people's account of affairs, and I think perhaps when we get to committee stage there might be more time to discuss this a wee bit more, to take perhaps some evidence, to see a bit more in detail exactly what needs to be done here, and exactly how far people can be pushed or cajoled or brought along, or whether or not we need to take this action and the extent to which that action has different force. Of course.
I'm quite intrigued by her contribution. Thank you. I'm quite intrigued by her contribution. I just wonder, we all want to move forward on the basis of consent, but I slightly disagree with the honourable member around how fast the overseas territories are moving. It's been 5 years since David Cameron first encouraged them to develop public registers of interest. Could she give us some indication of when she thinks actually the broader interest of having those public registers and the role that could play in tackling financial crime overrides her absolutely instinctive desire to seek consent in moving forward? When would you?
Yeah, I would agree, and that's the point that I was trying to kind of make fairly badly, I suppose, that how long do you leave it? And perhaps is 5 years with no sign of anything, or is there 5 years with some sign of something? I think we need to have more conversations just to see exactly where that is, but I am very keen on her amendment and would be keen to support that. I think where there is slightly more concern is with the likes of the overseas territories, with the British Virgin Islands, with Bermuda. When we look at the extent of the Panama Papers, of the Paradise Papers, we cannot fail to be concerned, and deeply concerned, by the extent of nefarious transactions that have gone on, of theft, out-and-out theft, of money laundering, particularly when it comes, as other members have said, of the siphoning, the guzzling of funds from countries whose populations can least afford it. And we should be very deeply concerned about that. And there seems to be very little indication that they will comply at all with anything. So perhaps there is a different approach between the Crown dependencies and the overseas territories in terms of how willing they are to comply with what has to be done here to make things transparent and open. Moving on to part 2 and clauses 43 and 44, and getting towards the register of beneficial owners of overseas entities. This is very encouraging, but again, this is the thing with this bill. Action is required. Action is required in checking up on all of these companies and all these registrations. Action is required in enforcement and in prosecution. And action which requires enforcement requires agencies, requires intelligence, requires people, requires boots on the ground to actually make sure that this is done. Because it's fine to have law, but if you don't have anybody to enforce that law, it's absolutely no point at all. And that's where I move on to Scottish Limited Partnerships as a particular example of where things are not being enforced. Now, this was bequeathed to me by Roger Mullen, for which I'm very grateful. And it is estimated by Richard Smith and David Leask, who have been working very hard, and you'll have seen some of David's reports in the Herald, that there are an estimated 20,000 to 28,000 SLPs which are of concern. And the Herald reported recently that a former president of Peru has been accused of taking £4 million of bribes which have been funnelled through a shell firm based in Scotland. Now, these should be things that are checked up on. These should be things that enforcement action has been taken on. But SLPs have become a cover for all manner of murky and dubious behaviour. And where the missing link in all of this is, and Transparency International and others have said, the missing link in all of this is Companies House. Because Companies House does not have the duty to refuse a company its registration. It has to register the company. It doesn't check up as to whether or not it's legitimate, whether the people that are registering it actually exist. And they are less compliant than agents who use them. So there is no benefit to going through an agent if you can go through Company House and avoid all the scrutiny. And that is a loophole that we have an opportunity within this bill, I believe, to actually close. Because Companies House, for me, is ignoring its money laundering duty here. And there are wider concerns about shell companies, and I would invite the Minister to look at the case of New Zealand, who were in a similar situation, but whose regulations have seen a near eradication of the 5,000 shell companies that they had registered to only about a dozen addresses in New Zealand. And part of that was a requirement for a New Zealand-based director, which made a huge difference to that almost overnight. Of course.
Leader for giving way on that point. Another interesting example from the recent Labour government in New Zealand has been the idea that they will actually be banning overseas ownership of property, given the huge inflationary pressure in the UK housing market from usually opaque overseas ownership of UK property. Perhaps that's a measure that we ought to consider in this country as well.
Be a very useful addition to this. The Secretary earlier did not answer the question on the 5th Money Laundering Directive, how this will be transposed, how it will be scrutinised, if there is a transitional phase, what does that transition look like, how do we prevent any loopholes and make sure that criminals do not exploit it within that transition. And I wish to finish, Madam Deputy Speaker, you'll be glad to know. Yep.
Perhaps at this stage I can give the Honourable and Right Honourable Ladies the answer they're seeking on the 5th Money Laundering Directive. It was published in the summer of 2018. Member States will have 18 months to implement, but that will be after we leave the EU. So whether we or Gibraltar are legally required to transpose will depend on the terms of the implementation period, which is, of course, under negotiation.
That appears to be a kind of I don't know vague kind of answer. I see the Honourable Member for Bishop Auckland perhaps wants to intervene also.
I'm very grateful to the Honourable Lady. Perhaps she'd like to ask the Minister whether the powers that he's taking in Chapter 3, temporary powers in relation to EU sanctions list, won't give him the power to enforce the 5th Money Laundering Directive.
That's a very good question indeed, and I don't know if he wants to take the opportunity to answer that just now, because I'm sure he has heard it and I don't need to repeat it. Perhaps not. Finally, but I would like to make some reference to the Scottish Government within here as well, because aspects of this bill reflect some of the powers that lie within Scotland. The Court of Session is referred to at 33.2, at 34.2, and I would like some information on what consultation has gone on with the legal profession in Scotland and with the Scottish Government on this. Also, on the Clause 34 regulations general provision there, which has the power to change devolved legislation under the negative procedure too, which is really not cool. It's not just me that is objecting to this. The House of Commons Library briefing on this states, this enables ministers to make supplemental, incidental, consequential, transitional or saving provisions, repealing or otherwise amending existing legislation, including devolved legislation. Lord Judge referred to this clause as monstrous, Madam Deputy Speaker, monstrous. Surprise, I am dying of not surprised here, but I want to know, on this monstrous provision that is in here, has the Scottish Government been consulted? What has the Minister got to say about this? This power grab, hidden on page 35 of the bill, is something that I will seek to amend in committee. I support any moves within this to improve the scope of the bill, Madam Deputy Speaker, and I look forward to hearing the rest of the debate.
Hear, hear.